The things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody. Thanks so much for joining the show. We appreciate you being with us today. We're talking about tips for asset planning. We're going to get into the weeds about asset planning. I'm Andy Fowler, and I usually do this show with my partner, Sean St. Clair, who unfortunately is not here with us today. If you're new to the show, make sure to give us a like. You can find us on Facebook, and you can find us on YouTube. On YouTube, we are at INREM Podcast. Again, our handle is at INREM Podcast. We'd appreciate it if you'd go to YouTube, subscribe to our channel, like it. That would help us out greatly. We would appreciate it. With that, we're going to go into some news of the day, some things that the INREM Podcast is involved with and is going to be doing. So tonight is the buy and hold meetup. You've heard about it before. We've got a flyer here to show to you. It is a monthly meetup held tonight on March 28th at 4 p.m. It's held once a month at the end of every month. And here are the topics that they're going to be discussing: home prices and monthly mortgage rates, prediction for 2023. You'll notice one of the speakers is Tina Tambor. You might recognize her as she's been a guest on the show. And they're going to give their analysis of the market. The buy and hold meetup is a great opportunity for real estate investors, for anybody in the space that wants to meet individuals, wants to meet folks, and learn more about what it is to buy and hold real estate and be a real estate investor. Make sure to be there. Now, what are we going to be doing there? So if you haven't watched before, we'd love for you to be at the event. But whether you're going to be at the event, you have the ability to watch us live from 4 to 5. So at 4 o'clock, we start kind of a live red carpet show prior to the event where we talk to the speakers, where we answer legal questions. This is a great opportunity for you to learn information, but get your legal questions answered. Sean and I try to make ourselves available about 6 to 7 times a month. This show is one of those examples. The buy and hold meetup, which is done once a month, is another example where you can come be a part of the show. If you want to be on the show live in front of the world, because the world's watching, right? And watch and ask a legal question, we're there to answer it for you. So make sure to be there. Again, that's the buy and hold meetup tonight at 4 to 6 p.m. at the Scottsdale Area Association of Realtors. They're going to be live streaming 4 to 5 o'clock. Also, our Creative Finance Symposium. Creative finance is hot. It's a big topic in the real estate investment space. And we hold a bi-monthly, so every other week, Creative Finance Symposium. This is not shot. It's done live, but it's not aired out for everybody to see. It's done with a group of people. Now, you can be a part of it. It doesn't cost you any money. You just need to reserve a space and come to the event. We hold it from 6 to 7 p.m. every other Thursday. The next Creative Symposium event is Thursday, April 6th, and that's from 6 to 7 p.m. The topic we're going to be discussing are key provisions in the subject to addendum. So the last time we talked about key provisions in the purchase agreement or other key provisions within subject to documents, we're going to be boiling down and focusing like a laser on the subject to addendum, what it's for, what you need to have in it to make sure you're using the subject to addendum appropriately. So make sure to be a part of that. You can find that information on our INREM Facebook page. You go to that, find the Creative Finance Symposium. There's a link to register, or will be, and that's where you want to be a part of it. Again, we make ourselves for about 30 minutes. It's an interactive event. So for about 30 minutes, Sean and I are there to answer any and all questions relating to creative finance. So if you're involved in certain deals, or looking to be involved more in the space, but you're worried about, what are some of the legal implications or consequences associated with different things, or things to look out for, that's what we're there to discuss. Finally, every week we do a live show, and this show is no exception, and we try to make ourselves available, as well as our guests on the show, available for questions to you. So if you have questions today, we're taking them. So what we want you to do, if you're watching the show, is think about what questions you have, but don't wait till the end to post them. You can post them by comment. I'm going to let Mayu here kind of give you instructions on how to go about doing that.
Yep, happy Tuesday, investors, and thanks again for joining the INREM live show today. You heard Andy. As always, we will be answering your questions at the end of the show live. So if you're watching us, whether it's from our YouTube channel or Facebook streams, and you have any questions related to today's topic, which is tips for asset planning, you can drop your question in any live chat, and we will be monitoring for them, and we'll try to get to all of them in the last 10 to 15 minutes of the show. So let's get into it.
All right. Thank you, Mayu. Yes. Again, reminder, if you have questions, post them now. If you're like me and you wake up in the middle of the dream and you have a brilliant idea that's going to save the world and is going to cure cancer, but you wait to write it down until lunchtime, you will have forgotten about it by then. So write down your questions, put in the comments, and we will get to them. With that, we're going to get into our topic today. We are talking about tips for asset planning. So we're going to get into the weeds. We've talked about this on a few different occasions. Sean and I have gone through things to look out for, the differences between asset planning, for instance, and estate planning, and what that looks like. But with us today to discuss asset planning is Colorado attorney William Bronchick. Bill has been on the show with us before. You might recall he's kind of the land trust guru over there in Colorado, and we had a whole show devoted to him. Bill, thanks so much for joining us. We appreciate you being with us.
My pleasure to be here.
Yeah. So for those who either are new to the show or haven't seen it before or unfamiliar with you, why don't you tell our listeners a little bit about yourself, your practice, and how you got involved in doing what you do?
Yeah, I've been a practicing real estate attorney for 32 years, originally in New York, came to Colorado in 93, and I've been licensed here since 96. My practice is primarily real estate, residential and commercial, representing mostly investors. I also do asset protection for them and estate planning, as well as set up self-directed retirement plans, IRAs, 401ks, and so forth. So I have a fairly limited practice to those four things, and they dovetail over because my real estate investor clients tend to be wealthy and they need asset protection and estate planning.
Great. Well, we appreciate you taking the time to be with us. I know that our last episode with you on Land Trust was really informative, and we got a lot of interaction from our viewers about that. They really enjoyed it. Tell me about, and I would encourage everybody who's watching, Bill's a great follow on Facebook. Not only does he offer good legal information and good information for those who are kind of within that community and looking for it, but he offers a lot of interesting stuff, and I'm a follower of Bill's, and I thought this was really interesting. Doesn't relate to our topic at all, but it doesn't matter because I think it's cool. So Bill, you were recently in a rock band camp and you were performing with the former lead guitarist of Soundgarden, and maybe Soundgarden's still going on. Maybe he's still the lead guitarist, but I know their lead singer's no longer around. So
Right.
Tell me about that and what that was like.
Yeah. So my brother, who's a guitar player, and I've been one since I'm 8 years old, we've been going to this rock and roll fantasy band camp for years and bugging me to go, where they have, over the hill guys like us who want to play with over the hill rock stars, who are generous enough to share their time and expertise and, give us lessons and advice, and we get to jam with them. So I went a couple of weekends ago, and we got to play at the on Sunset Strip in LA. We got to play at the Viper Room Saturday night, and then Sunday night at the Whiskey A Go-Go, which was amazing because I'm sitting in the dressing room going, the Doors played here. The Doors played here. Frank Zappa played here. Guns N' Roses played here. Yeah, I can't believe I'm in the same place on the same stage, and it was a packed house and it was a lot of fun. So I got to play Sunday night with Kim Thale from Soundgarden, and then on Saturday I got to jam with the DeLeo brothers from Stone Temple Pilots, which was great. And on Friday I got to jam with Carmine Appice, which is one of the greatest drummers in the world.
So is this when you say you get to jam with some of these icons, do they give you any time to prepare? Is this impromptu? Here's the song we're gonna do. Get ready. We're doing it in E minor. Let's go, kind of thing.
Pretty much. It's like, this is what we're gonna do, and we were trying to figure out a Soundgarden songs, and he's really a good guitar player, and the songs are complex. The theme of the event was Led Zeppelin, so I said, let's just do a Zepp song with him. He probably loves it. And he's probably sick of playing his own songs, and he loved it.
Oh, wow. Super cool. Well, that's very interesting. So if you like any things other than land trust and asset planning, you're into rock and roll, Bill Bronchick's your guy. Appreciate you talking about that. So let's get into asset planning. I know you do. I know you do a good bit of that, but we're going to work our way kind of from the floor here and then up into the clouds. And so let's approach this right from the beginning, from the perspective of maybe just a newbie entering the space. They've seen YouTube videos about creative finance and about wholesaling and all these different real estate related things, where they're getting into business and they want to go make their place in the world. We know as attorneys, there's a lot more to it. There's a lot more about how you set up your business, how do you protect yourself, and everything else. But just generally, why don't you kind of lay the groundwork here? What is asset planning, and why should we care about it?
Well, asset planning is learning to protect yourself and your business and your family from lawsuits, from liability, from taxes. It also has some component of estate planning and limiting estate taxes, and protecting yourself to become legally judgment proof, so that if something goes wrong, sometimes it's something that you did that was intentional or bad faith, but most of the time for us, we're looking at situations where someone just messed up because they didn't know what they didn't know, or maybe they had an employee or their broker or their property manager or their contractor screwed up, and now you're on the hook for something. Or maybe it's just a deal where you're on a big loan and the market goes south and you're liable for millions of dollars personally, and you want to be able to protect yourself and feed your family. So those are all in the category of potential risks and pitfalls. I don't want to scare people away from real estate, but real estate's a high risk business. It is. And a lot of people start out from the beginning saying, well, I'll just do a couple of deals in my own name, then I'll form an LLC or a corporation later when I have money. Well, there's a statute of limitations where people can come back years later and sue you on a contract that you did in your own name in the beginning, even if you set yourself up later. So I always tell investors, you don't have to do all of it at once, but you build a business like you build a house on a proper foundation. If you build a house on concrete, it's going to have a good foundation. If you build it on plywood, it's going to rot out and eventually collapse.
Yeah, and I think what a lot of people don't appreciate, you mentioned real estate is a high risk proposition. Anymore, life is a high risk proposition, and you're in business long enough. It's not a matter of if; it's a matter of when you're going to be dragged into some sort of dispute, whether that's a contract dispute, whether that's not anything you did. Maybe it's a guest slips and falls on property because of a leak that you didn't know about, or something to that effect. Life is life, and it's going to happen. So underlying this whole asset protection and business formation is this idea that the law treats entities, properly formed entities, that is, as really sole and separate persons under the law.
Right.
And I think that's what kind of underlines a lot of this in structuring yourself in such a way to help protect yourself. Explain to our listener what that means to be treated as really a separate entity in the law, and this idea that you and I and lawyers use the term corporate veil a lot,
Mhm.
right? So we know what that means, but why don't you explain really what that means in the eyes of the law when we're talking about an entity that's been formed versus us acting individually?
Right. So, giving a common everyday example, if you own stock in Google and Google got sued, you as a stockholder are not liable. You're not personally on the hook for that because of the corporate entity, Google. And it's really no different if it's just you or you and your spouse or you and your family in a small company where you're the owners of the company and the company somehow picks up a liability. The company takes the hit, not you. Now, there are many, many exceptions to that. And probably the biggest one is if you're the actor who did the wrong individually, let's say you're a landlord, and let's say that you screened a tenant and allegedly discriminated. Well, if you're the one who did it, you're going to be on the hook too. So is the company because you're acting on behalf of the company, but you're on the hook as well. But your other owners of the company, maybe your rest of your family, might not be as owners. On the other hand, if you had a situation where you own a property and you had a property manager who discriminated, well, they'd be liable. And then because they're acting on your behalf, your company would be liable, but not you individually, because you didn't commit the wrongdoing yourself. So it's situations mostly where other people do things for your company, or maybe it's just like a company policy thing that ended up in a liability, such as you used a certain type of maybe a product in your rental property that someone was injured physically because of that. Unless you committed negligence, individually, it's a company policy. The company's going to take the hit, not you individually. So it's a matter of, is there a judgment against you as a person or a judgment against the company?
I'm curious to hear what you think about this. So our last show that we dealt with was specifically dealing with getting insurance right in subject to transactions. And one of the things that came up in that discussion is this tendency, at least I find as an attorney, when I meet with clients about asset planning, I run into this it seems like I run into this situation often, which is they've looked online or they've heard from somebody that all they need to do is go form a bunch of LLCs and put their stuff in a bunch of LLCs. And as I probe, I find out that oftentimes it appears they're either doing this so they can save a little bit of money and not purchase insurance, and they're being cheap and they're not appreciating maybe the logistical nightmare that creating a tons of LLCs can do.
Mhm.
But how important is it, and how do you help your clients navigate the insurance question? When you're asset planning in structure, that certainly isn't a replacement for a good
Oh,
insurance.
no. Oh, see, a lot of people don't want to have insurance because they think it's a magnet for lawsuits, which it is. Most personal injury attorneys are going to go after insurance. And oddly enough, most personal injury attorneys I know who are colleagues, if there's no insurance involved, they won't sue the individual. It's sort of like an ethical code. Like, we don't go after people, we go after insurance companies. So having lots of insurance is a magnet, but on the other hand, it's a necessity. Not just because of the liability coverage, but because of the lawyer coverage. Most claims are settled. And even if you win, you lose if you have to pay 100 grand in attorney's fees. If you're sued for something that either wasn't your fault, is frivolous, or was your fault, it doesn't matter. If it's settled and you had to fork out 50 grand to defend yourself, you've lost. So having insurance gives you that, quote, free lawyer to defend your case. So if it settles or it's frivolous or you win, at least your attorney's fees are covered.
Yeah, that's a huge point. I'm glad you brought that up, and because nobody thinks about the attorney's fees on it, because it could be, and often is, a baseless claim, right?
Mhm.
It might be something that is going to, be an easy winner that a lawyer might think is, don't worry, we're going to win this kind of things. The facts and the law are on our side. But getting from point A to point B in a lawsuit is not some overnight endeavor. This thing called due process requires lots of time,
Right.
and if you're going to hire a lawyer, lots of money. So just paying that premium to have defense coverage
Mhm.
is probably worth it in and of itself. And it sounds like that's what you were saying as
Right.
well.
Yeah, I'll just give a personal example. I was sued for on a deal that went bad that I had nothing to do with the wrongdoing for over $800,000, and I settled it in the end for 10 grand with no admission of liability, but it cost me 150 in attorney's fees. It was an uninsured claim. So did I really win?
Yeah. No.
No. Well, I mean, it was a win that I settled an $800,000 case for 10 grand and with no admission of fault. That was
Right.
good, but it cost me 150 grand in attorney's fees to get there.
Yep. Yep. That's not an uncommon situation at all. So if you're listening, don't take the asset planning suggestions here at all as a suggestion that this replace
No.
insurance. In fact, it's really just, a supplement to it and help you better prepare with your assets. So let's talk about, and you've mentioned a number of these, but let's just talk about the scenarios that asset planning prepares for. Obviously, a big one you mentioned is being sued.
Right.
Give us some examples of what kind of lawsuits those could look like, and what are the other things that we're trying to prepare for when we asset plan?
Here's a very common one, which would not be covered by insurance. Wholesaler, beginner, puts a property under contract, wholesales it to another investor. Now, in the old days, it was very simple. We signed a contract, and then I signed a form called an assignment, which says I assign what I have to you for X dollars. Well, now what's happening is the person you're assigning it to might be inexperienced or didn't do their homework, and now they're blaming you, the wholesaler, for things that you allegedly didn't disclose about the property or allegedly did disclose that was incorrect. So I've represented, at least over the last 3 years, at least a half a dozen of those wholesalers who were being sued by the person they assigned it to. And you'd figure it's buyer beware. I mean, be a big boy, wear your big boy pants or your big girl pants, go do your own homework on the property. But now it turns out badly, and then the person who took the assignment is now suing the person who assigned it to them. And that would not be covered by insurance. That's a contractual or a misrepresentation claim.
Yeah, no, we see the misrepresentation problem a lot, as something that's going to be the coverage be denied if the claim is tendered to insurance. On occasion, it's picked up for whatever reason, but that's a problem. And that, of course, goes back to what you were discussing before, where ultra ego liability, not alter ego.
Retrovirus?
Yeah. So the corporate veil, that doesn't necessarily protect you from, your own statements and things like that. Another piece of asset planning too is, one, we're protecting against the liability or the expected or anticipated liability that may happen, but we're also spreading out assets, aren't we? Trying to divvy them among different entities or appropriate entities that are maybe doing business in other ways that other entities aren't. Isn't that part of the piece as well?
Yeah, absolutely. You don't want to put all your eggs in one basket. Obviously, if you owned everything in your own name and there was a lawsuit involving one of the properties, you could lose not only all your properties, you could lose everything, your home, your car, your bank account. But if you have an LLC, that'll protect your personal assets, hopefully, but it doesn't protect the corporate assets. Because if you own 10 properties in one LLC and that LLC is sued, everything that LLC owns is subject to potential collection on a judgment. So we do want to break it up into baskets of maybe high risk, low risk, or break it up according to equity. And the question, of course, you probably get it a lot. I always get it is, well, how many properties do I put in an LLC? And you always give them the lawyer answer. It depends. It depends on a lot of factors. If you're in California, for example, there's a minimum franchise tax per LLC of $800 per year. That factors into the equation. In Colorado, the filing fee is $50, $20 a year, no franchise tax. So, so there's the incentive to use more entities than less. But then there's a point of diminishing returns, because if you have 27 properties and 27 LLCs, how do you walk into court with a straight face and say they're all separate? and you're not giving the judge a lot of leeway. I mean, the plaintiff is walking in a body cast, and you're going, well, judge, he fell on property 15, and that property has 50,000 in equity. That's all he gets. And the other lawyer's arguing, don't fall for it, judge. It's all him. We want it all. You're not leaving the judge really a lot of leeway there. So you got to throw them a bone. You have to be willing to lose something. Maybe every 3 or 4 properties, you break it up into a new LLC. So, okay, instead of losing, trying to argue it's only 1/27th and potentially losing it all, maybe you lose a third or a quarter or 20%.
There's a little bit of a balance with asset planning as well, in that when you create that new person in the eyes of the law, that new person has obligations, files tax returns, maybe does a whole new set separate things. We're going to talk a little bit about alter ego liability in a little bit, but they've got their own duties and obligations, which means really more work for you, the creator. So I've always kind of thought there's a little bit of a balance wherein the more asset protection you do on one hand, oftentimes the more work it might require of you on the front end, or more organization it's going to require. Does that oftentimes go into the analysis as to, well, how many LLCs or how many different ways do I want to split up the different assets?
Absolutely. I have to assess my client and see how much tolerance they have for doing the work, because I can set up the most perfect plan for them, but if they don't follow it, it fails. So I try to balance between, okay, what's going to protect them and what can they live with? I mean, how many bank accounts do you want to have? How many sets of books do you want to have? How much paperwork? I mean, some people set it up so crazy, you'll be having corporate meetings with yourself all day long. You won't have time to go buy real estate. So, there's a balance. There's no perfection and there's no one size fits all.
So client walks into your office and they've watched the show and they said, boy, I'm worried. The lawsuit's coming eventually. Even if I do everything perfect, I need to start preparing. At what point should somebody consider asset planning? At what point along that spectrum? Is it determined based on how much assets you have, how much business you're engaged in? At what point does the reality get to the point where you need to do this? Is there a line, or do you just say, hey, look, you're ready to go into business in one shape or form of another, do it?
Yeah, I tend to lean in that direction. If someone comes to me and says, I'm a brand newbie in real estate and I plan on buying $1 million worth of properties this year, well, maybe they will, maybe they won't. I'm not going to go crazy with it. I'll at least encourage them, start an entity of some sort to do your business and your wheeling and dealing in. And as we grow, we'll add more to the equation. But waiting until you're threatened with a lawsuit is a disaster, because, and I get that a lot. People come to me, I've been threatened with a lawsuit, or, someone has wrote me on a lawyer letter, because there's something called a fraudulent conveyance. Everything you do in the face of a known liability is considered a fraudulent conveyance. And it's not like fraud in the sense you go to jail, criminal fraud. It's that it's a transaction that a court can undo. So if all of a sudden someone's threatened to sue you and you start moving assets around, it probably won't work, because the judge can say, nice try, and put it back in your name so your creditor can get it. In addition to that, now those are actual knowledge of things. There's a look back period, a statute of limitations, that things are presumed to be fraudulent. And that changes from state to state, 3, 4, 5, 6 years of a look back period, where everything you did, even though nothing was going on, even though you had no suspicion of something going on, if you go to court, the presumption is that you did it to avoid creditors, and then you have the burden of proof not to prove otherwise.
Yeah, it's amazing how a moment of just a moment in time can change from your actions being actions just taken, done in planning and asset planning, to avoiding creditors, and the consequences can be dire. And these steps shouldn't be taken lightly. I think what we would hope that nobody confuses us in saying is that appropriate asset planning is not just some game you play necessarily to um, just strictly to avoid creditors. It's putting appropriate assets in appropriate boxes,
Mhm.
and then it's respecting the formality of those boxes. We talked about this before, but my biggest problem, or when I say before, we've talked about this in other episodes, where the problem in real estate, especially with like the creation of the quitclaim deed, is so many investors think that they can just willy-nilly convey property in and out of things. And they fall into, you mentioned fraudulent transfer, but they fall into weird stuff where they've transferred things to their family or friends or insiders, as a statute might refer to them. And, like you said, there's ways for the law to claw those things back and get that back. But you like folks to really begin thinking about the asset planning process really as early as they can.
Yeah, and it's because of that statute of limitations for the fraudulent conveyances. If you start now while there's no problems and you get over that statute of limitations, and then someone sues you, now it's their burden to prove what you did was to avoid the creditor, not your burden to prove it's not.
Yeah, shifting the burden
Mhm.
changes everything
It does.
at the initiation of the lawsuit and puts you in an entirely different position, or the defendant, that is, in the entirely different position. So let's talk about asset planning strategies. I know that there's a number of different ways. Want to get your takes on a few of them. The limited liability company is probably the most common.
Mhm.
At least in Arizona, that's the case, just because uh, you have so many options in how you want to run it, how you want to direct it, how you want to tax it,
Mhm.
and all those different things. I suspect that's the case in most places. Is that what you find in Colorado, the limited liability company being the most
Yeah,
common?
in most areas, people are using LLCs because there's a variety of ways that you can choose to set it up logistically for running, but also for tax purposes. It could be taxed as a partnership. It could be taxed as what we call a disregarded entity, where you would just ignore it and report on your personal return. It could be a corporation, an S corp, or a C corp. The only exception to that would be like the only thing I could think of is New York. In New York, you have to publish a copy of the articles of organization in a paper, which in New York City is like $1,200. So if you want an S corp, you form a real S corp instead of an LLC, electing to be taxed as an S corp. But I think for most people, the LLC is the primary entity, and the choice is just how are we going to elect for taxes to run it, and then are we going to have uh, managers or no managers, or is everybody going to be involved in the decision making, or some people are going to be passive investors and so forth. But one of the things I like about the LLC as opposed to a corporation, even if you want an S corp, you can have an LLC taxed as an S corp. It means the IRS will treat it like one, but at the state law level, it's still an LLC. And LLCs under state law require very few formalities, as opposed to corporations, which require bylaws, stock certificates, minutes of meetings of directors and shareholders and so forth. Where the LLC, in most states, the state statute doesn't require it. And further, the state statutes say that failure to hold those meetings is not a reason to pierce the company veil.
Mm. How much to you does state of formation matter? And I guess where I'm going with this, obviously, you're a Colorado attorney. You know
Mhm.
Colorado law. I'm an Arizona attorney.
Mhm.
As a general rule, I want an Arizona LLC registering here in Arizona. But there's a fad all about anonymity, right?
Mhm.
In states that provide anonymity when you do that. So, I get this question a lot. Well, yeah, I'm here in Arizona, but I want to do a Delaware, Wyoming,
Mhm.
limited liability company. How much does that matter to you? Do you think that's overthinking it?
Well, I'll give you the lawyer answer. It depends. Because, yes, Wyoming is a low information state, so is Delaware. But if you have to register that entity in a high information state as a foreign entity, you're still going to have to give up the information. My state of Colorado is a low information state. They don't ask for names of managers or members. So it's fine. And then I, as the attorney, am the organizer, registered agent, and filing person. So my client's information isn't on the filing at all. And a lot of people like that, especially if they have rental properties and they don't want people to be looking up the owner's address or who the real owner is, especially if they have a property manager. They want to keep that anonymous. And what most people do is they form it themselves online without an attorney. They put their name all over it, their personal address all over it, and they're losing that anonymity factor.
Yeah, well, that's what I've always found with the anonymity question is that it's hard enough for them just to keep the books and records of the LLC organized. To not take the steps that are going to disclose who they are is very difficult for most people to appreciate on a day-to-day basis, and so easy to basically undo. Let's talk about trust. You mentioned estate planning is sometimes a piece of asset planning. A lot of the times it's going to be, especially as our clients grow their assets and they become larger, it becomes sometimes a necessary part of it. How do trusts work into the equation of asset planning? And that's whether we're talking about revocable or irrevocable.
Most of my clients will set up a revocable living trust for estate planning. And the way we do it is different than most estate planning attorneys. See, most estate planning attorneys will set up a living trust, and the purpose of the living trust primarily is to avoid probate, which is a state court process by which lawyers get rich. So, but it ties up the estate and it costs a lot of money. So the living trust avoids the probate process. And that's why most people set it up. There's other reasons too, but that's the main one. So what the typical estate planning attorney will do is if someone owns, let's say, 5 rental properties, is they'll put all the rental properties in the living trust, in the Bill Brownchick living trust. First of all, there's no anonymity in that. And second of all, there's no protection because living trusts don't provide any kind of liability protection. What I recommend clients do is they put their properties in the various entities, and then the entities are owned instead of by them by the living trust. So what they're handing over to their heirs is not the assets. It's the keys to the companies that own the assets.
Yeah, there seems to be this kind of universal confusion about trust. And I'm curious to see whether this has been the case for you, but just like the same folks that come in and want 1,000 LLCs to do asset protection without insurance are also the same individuals that usually also want a bunch of trusts, and they want everything in a trust because they think that works just like an LLC. And at least a revocable living trust does not provide any asset protection. At least it sure doesn't here in Arizona.
No, in any state it does. There's not. I mean, there are some states that have statutory trusts that are revocable that, in theory, give protection to the grantor, the creator of that trust. First of all, they don't work outside of the state where you formed it. And second of all, they don't work that well in the state you formed it. The only true revocable trusts that'll give you kind of protection is the ones that are truly like offshore. And that's really only good for things you can move offshore, like money. An offshore trust owning an LLC in Arizona is probably not going to work. A judge is not going to honor that.
Let's talk about assets. Yeah. Okay. So let's get into land trusts. I know you've got a lot to say about land trust, but when do you like to incorporate the land trust into an asset planning equation, or is it part of the asset planning equation?
Kind of yes and no, because a land trust doesn't provide you with any real liability protection. It's anonymity again. So let's say a client formed an LLC already and his name is all over it. If he puts title to the property in that LLC, someone can go to the Secretary of State and look up who's the owner. If he puts it in a land trust with the beneficiary of the land trust and LLC, the tenant or someone else could look up the property owner at the county deed records and see it's owned by an anonymous trust. And trusts don't require a registered agent like an LLC does. It could be a PO box. It could be an out-of-state PO box. And now they have these things called virtual PO boxes where you could be anywhere in the world and they'll scan and send you your mail, which is beautiful for anonymity. So the land trust, the purpose of the land trust is simply confusion. You put your property in a land trust, each property in a separately anonymous trust, separately titled anonymous trust. And if some lawyer is looking into it, or a code enforcement, or a newspaper reporter, or an ex-spouse, and they look up the owner of the property, they're going to see a trust. Well, where is this trust registered? It isn't. It's not like an LLC where there's a database you can look it up.
So we've talked about asset planning, setting up LLCs, and the different vehicles on how we want to prepare for it. And, obviously, wherever you're listening, you go to a lawyer who knows what they're doing in that state. Make sure to get it done right.
Mm-hmm.
But there's this process of getting it done right. And then there's this process of where the client undoes everything that you've done. I like to tell, with respect to estate planning, I like to tell my clients that I could, and I'd like to think that I can create the greatest trust that you've ever seen, that does everything that you ever wanted it to do. But if you don't place assets in the ownership of this trust is basically worthless.
Right.
So the same could be said about asset planning, I think. If you don't respect certain things, if you don't treat companies like companies,
Right.
and we know this as lawyers. So let's talk about actions that individuals can take to undo their liability protection. And in the law, we call this piercing the corporate veil. So the veil of protection that the limited liability or the corporation or whatever the entity structure you chose was that provides you that corporate veil of protection, that can be pierced. So let's talk about instances. Well, let's just start here. What are the most common instances you see
Mhm.
that result in the ability of a creditor to pierce the corporate veil and go after the individual assets of the owners of the company?
The most common is money. People keep poor books. They move money from themselves to the company and from the company to themselves or an affiliated company with no rhyme or reason. It's okay to put money from the LLC bank account into your personal bank account, but what is that transaction? Was it a loan? Was it a draw? Was it a repayment for expenses? Do you have a piece of paper like a credit card statement in your files to support that reimbursement for expenses? Imagine you're working for somebody else. Would your boss say, hey, it's okay, I'll take your word for it that you spent $1,200 on your credit card, here's a check? No. You would expect to fill out a reimbursement form and give a copy of your receipts and your credit card statement and so forth. So you have to treat your company as if it were somebody else's company and follow the rules and not rob Peter to pay Paul. But if you are going to rob Peter to pay Paul, do it in a way that is legitimate, that is arguable, that follows generally accepted accounting principles to the best that you can, and that your books are clean.
Yeah, and in the law here, they call it treating the LLC like a shell, sham, or instrumentality, right? If you're not going to respect the corporate formality and you're not going to treat this as a company, then what you're really saying is you just want this fiction to protect your assets, and you really weren't in business at all. What I find, and I'm curious to see if you think this is similar, but most of these mistakes that happen aren't malicious mistakes in an attempt to run from creditors. For instance, what I'll see oftentimes are people, maybe it has to do with taxes, because there's a temptation to make everything in the world a business expense, right? To try to basically, if I can pay for this now before taxes and call this a business expense,
Sure.
it's just a way to spend more of my money without doing it. So then all of a sudden, ABC LLC is now paying for little Susie's ballet lessons or little Jimmy's piano lessons. And then the list goes on and on and on. And then, like you said, those aren't properly categorized. And those are things that shouldn't have been probably spent on to begin with. But that little debit card of the LLC is so easy, and there's such a big tax benefit to treat that as kind of an expense. That's where I see that happen a
Yeah.
lot, not in an attempt to just avoid
Yes,
taxes.
yeah, and we call that commingling of funds. So you're using corporate funds to pay for personal things, and you're using personal money to pay for corporate things without following the proper protocol. It's okay to pay for little Susie's dance lessons, but don't pay for it out of the company's bank account or credit card. Write a check to your personal account. Either it's a loan, it's a reimbursement of capital, it's a draw, whatever it may be, and then spend it out of your personal account. Don't go to the supermarket and go, oh, gee, I forgot my personal credit card. I'll just use the company one. Well, in some circumstances, if you reimburse the company for that and you have a form and something to back that up, it'll be acceptable. But most people don't. They treat their company as a piggy bank that's personal, and they spend personal things and corporate things on the same credit card, and it becomes messy.
Yeah, and where we see this on a bigger business level too, in the real estate world, is sometimes with contractors and fix and flips, where they're doing multiple things and they've got multiple entities going, but then they got this big pot of money. And this subcontractors, they've just finished, and this one's just finished, and we're just paying, and we're not paying attention to what bank account comes out of what. And I think this goes kind of to our earlier discussion about knowing what sophistication level you're at. If you're going to be involved in this level of business, you have to really be ready to, put your big boy pants on and maybe spend the money to get bookkeepers that know what they're doing to track money and everything else, because the consequences are pretty dire, or can be.
Yeah, and that's a real good point you made there. Bookkeeper, very important to your business. Your CPA is going to charge you a fortune to keep your books. You could do, or your spouse or someone in your company who works part or full time can do the entries into your software. But having a bookkeeper at least once a month look it over and do trial balances and profit and losses and say, hey, something's not adding up here. Or what were these expenses that you put on the company credit card? I'm trying to reconcile them, and they can't figure it out. If you wait till the end of the year, or even worse, you wait till you get audited or sued, it's going to be a mess.
Yeah. So you mentioned it a little bit ago, the fraudulent transfer statutes, and every state's got its own version of fraudulent transfers. But the general idea is moving money to essentially avoid creditors, and oftentimes indicators of that are, it can be moving it to insiders or moving assets to insiders and these kind of things. And you talked a little bit about the remedy being the ability to basically void that or undo that. What does that kind of action look like in Colorado?
It's basically they claw it back. In the collection or even in the lawsuit, they can claim that certain items that were transferred were fraudulent conveyances intended to defraud that specific creditor, or it was within the statute of limitations. So therefore, it's the burden of proof is on the person who transferred it. So it could be done in the lawsuit. It could be done post-judgment collection. And that's why I really urge people to not wait until, oops, I messed up, and start planning, because it's probably not going to work. You're probably going to be more likely talking to a bankruptcy attorney.
Yeah. And I think it's particularly troubling with real estate, because you can move real estate assets by conveying a deed, and you don't even need the grantee of the deed's permission to do that. You can just go do it on just sign that deed, convey it, and record it, and it's done. And so, unfortunately, when folks think they're getting cute, I like to say, if it sounds cute then it is cute, and so you probably shouldn't do it. But if you've been threatened with a lawsuit and you think you're going to be able to just convey this property into mom's name and nobody's going to take an issue with it, well, mom's going to be a defendant in a lawsuit, right? So yeah, don't do it. So one other piece of liability issues, or issues where liability can flow through beyond the corporate veil of protection, is successor liability. Why don't you explain instances you see of successor liability and what to watch out for there?
Yeah. So successor liability is you have a business, somebody sues you, and basically you just move all the customers' assets, lease everything to another company you set up. The new company would be liable for the debts of the old company. That's successor liability. And sometimes it's not really intended that way. I've seen situations where in my office building where a small firm that had a lease with the landlord merged with a bigger firm, and they sued the bigger firm for successor liability on the lease.
Mm.
And I thought that was crazy, but it didn't get thrown out in court. So you got to be careful there. You can't just say, well, I'll get sued, I'll just shut everything down and start up a new version of the company. If it's the same owners, if it's the same customers, if you've moved all the equipment over, it's gonna be successor liability. Now, there's ways to get around it. I mean, you could legitimately set up a new company with maybe a couple of new owners that are friends and family, and then buy the assets and the receivables from the first company at fair market value. Then it looks less like successor liability. But there's a fine line there, definitely, about the old company versus the new company, and is it really a continuation of the old company that would inherit the liabilities of the first one?
All right. Bill, I think we have a couple questions for you. Mayu, what questions do we have from the listeners?
Yeah, now it's my favorite time of the show. We only have a couple questions. Thank you guys for asking them. So I'll read the questions. You, Andy, and Bill, you guys can answer them. So the first question here, this is going back to insurance. How does someone know if I have insurance on my properties or not? Is it public record?
That's an excellent question. And the answer is no, it's not public record. Typically what happens is an attorney will write a letter saying, we think you might be liable, contact your insurance company. And then it's up to the person who receives the letter whether or not they want to do that. If you get one of those, definitely do it. Disclosing your insurance, a lot of people are hesitant to do that. If you don't notify your insurance company timely of a potential action, they can disclaim coverage. It's very common. My first job out of law school was working for insurance defense. And my job at the law firm was, here's the policy, here's the claim. How could we get out of paying this? That was my job, to help the insurance company screw the insured. And the most common thing was a lawyer, an engineer, a doctor who screwed up, knew he screwed up, kept it quiet, and then got sued years later. And the insurance company says, no, we're not covering it because you have a duty under the policy to timely report any incident that might lead to a lawsuit. And when you get your renewal each year, you've probably seen this, they ask you, did anything happen in the last year that might lead to a liability? If you say no and you hide it because you're afraid your rates will go up, when the claim comes a year later, they're going to deny the coverage.
I just don't understand this for the life of me. I get this all the time. Andy, we got this letter. What do we do? Well, tender it to your insurance carrier. Well, I don't want my premiums to go up. Do you know how much this is going to cost you if this
Right.
insurance company does not step in and defend you?
Right.
You let them know right away and
You're
stop
not getting
worrying
a
about
free lawyer.
Yeah. And you mentioned it before. The fees on these kind of things are astronomical. The amount you pay in the premium or the amount that it might go up is a pittance. It's nothing.
Right. Yeah.
All right, Maya, do we have another question?
Yeah, last one. So this one's a longer one. If I have 3 properties under my name in California, what's the best way to transfer them to an LLC? What is the statute of limitations where others can come after me personally? In addition, does that LLC have to be created in that state?
Wow. That's a lot of ifs and a lot of depends. Well, without giving specific legal advice, I'll answer the general questions. Transferring a property to an LLC is done with a deed. And in California, it could be a grant deed. They don't use warranty deeds there, or a quitclaim deed. California entity versus out-of-state entity, it doesn't really matter in the case of owning property yourself, whether you form it in Delaware, Wyoming, or Nevada, or California, because California has such an aggressive taxing structure with their franchise tax that if any of the managers even live in the state, you have to register it and pay that tax. So literally, you can have a Wyoming LLC that buys property in South Carolina, but the manager of that LLC works from California, and you have to pay $800 a year to California. I mean, it's like literally you stop and use the John in Colorado, in California. You gotta register and pay the fees. I guess that's a good question. We didn't really discuss when is it appropriate to form in another state? there are other reasons other than privacy. Certain states have better protection for what's called inside liability, meaning if you're, let's say, a syndicator and you have partners and they allege that you breached your fiduciary obligation to them and they're going to sue you, it's the state of formation law that counts, not the state in which the property is.
Interesting.
So that's why people form Delaware, because almost every New York corporation is formed in Delaware, because shareholder liability, director liability from, to the shareholders is dictated by the state of formation. And in Delaware, they have the loosest laws with regard to that. So if you're going to, let's say, do a syndication with a bunch of partners and you're in California, you might want to form a Delaware LLC.
Interesting. Do you ever see, just kind of jumping off that, members or partners invalidating the application of the forming state's law because they put the wrong language in an operating agreement, let's say, or as to what law might apply, or does that have you seen whether that even changes the equation?
I haven't seen an equation. I don't think I've ever seen someone put in. Well, I guess that's not true. I have seen that, where people form an entity in Nevada and then pull a form off the internet that says the state of California applies.
Yeah.
I would suppose contractually that would be the case.
Interesting. The other thing, I guess, what I would point out when dealing with multiple states, and I'm just thinking of all the problems that I've seen. What I see a lot of people do when dealing with other states is they form Arizona LLC and Arizona Limited Liability Company, and then they think, well, now I bought a property in Colorado, so I'm going to go form Colorado ABC LLC, so same name but a Colorado Limited Liability Company. Then they do that in every state that they go in. Now that's okay to do if your intention was to have all these separate entities, but a lot of people do it thinking, well, it's the same entity. I'm just filing in this new state, and it's no, you've just created a new entity under a new law. That's not the process, right? There's a process to these things, like domestication and so on and so forth.
Right. And the other thing too is that, and the law is different from state to state on this, is the rule on charging orders. There was a recent case in Colorado where an Arizona creditor and a Colorado creditor were fighting over a charging order, and Colorado Supreme Court said that the law in which the company was formed would apply for charging orders, which is very good, because now I tell my clients, good, form in Wyoming, which has very good charging order protection, register it in Colorado. In New York, they came to the opposite conclusion. Someone formed a Wyoming LLC, and which has very good charging order protection. New York creditor against that entity tried to get through the back door, and the court said no, New York law would apply, not the formation state. So every state has a different rule on that. Interesting.
Well, Bill, thank you so much for being with us. Why don't you tell our listeners what you're doing, what you're up to, and how they can connect with you?
Yeah. So my law firm website is Bronchick Law, BRONCHICK, the only name of its kind in the United States. Everyone with that spelling is related to me. So I'm a real estate investor. I didn't mention earlier, I've been a real estate investor for over 30 years, and I write books and teach seminars and do training on that. And that's my other website, which is legalwiz.com, W-I-Z, legalwiz.com. And I have a variety of online courses, and I do webinars, and even have a live boot camp coming up, which I'm very excited about, because this COVID thing really, we all have to get off this Zoom nipple.
Yeah. It's time to shake some hands, right?
Time to shake some hands and do some business with people. So I'm doing a live event. I'm going to record it, but I'm not going to stream it.
What's the event on?
It's creative financing. Just like
creative finance. So that's big in college. That's big everywhere, isn't it?
Yeah, it's big everywhere. I do a lot as a lawyer. All of a sudden, that side of my business has exploded in the last 6 months, because sellers are saying, "I want my price, but I don't want to drop it." And now I'm teaching brokers how to teach their clients, well, if you offer terms, you'll get a higher price.
All right. Well, let's do this again and talk creative finance. It's such a big thing. It's big everywhere. Bill, thank you so much for being with us. We appreciate it. We'll see you again soon.
Great. Thank you for having me on.
All right, everybody. Thanks for joining us. That is our episode today. Join us next Tuesday, where we're talking about collaboration is the name of the game, working with your realtor, how you as the real estate investor can help leverage and work with and cooperate with your realtor to find deals. With that, thank you for joining us. We'll see you next week.